All right, welcome back, brothers and sisters. We are green, we are alive, and we have got freedom hot and ready to deliver this amazing 2A to the next generation. Guys, what we're about to walk through is FPC striking again because mandatory waiting periods just got dealt the old backhand up in Maine. This is going to come together with a lot of things we covered before. This is going to show you some new stuff, and including a healthy dose of prejudicial laws against minorities that were referenced by the gun controlling side of the argument. This has got everything that you're going to want to need. Make sure you hit that like button, subscribe to the channel, turn the notification bell on. If you could help us grow, that would be incredible because the growth equals freedom. I thank you so much in advance. All right, guys, as we get in here, we've got it. We are good to go. Y'all are, wow, words. Checking in pretty fast. Audio, video is good. Excellent. Let's pop into this because anytime FPC strikes, whoa, they strike hard. All right. Now, guys, if you're not familiar, let me do a little backstory while everyone's getting in here so we can get this thing going. Maine put together some laws recently. You know, after the shooting in Lewiston, they put together a lot of different laws. There was yellow flag talk, red flag talk. Lots of gun control groups dove into there, okay? One of the things that they came out of that was a mandatory waiting period, okay? So a 72-hour waiting period. You want to buy a gun? You're going to wait 72 hours because that's going to magically solve everything. That was literally the argument. Okay. Well, Maine federal judge issues preliminary injunction against the state's 72-hour firearm waiting period. This is just the result, right? They do an unconstitutional infringement. The court system says you can't do that. But the extra garnish on top is when the state of Maine actually argues through their prosecutor and their DAs that, no, it's okay. We have history, texture, and tradition because we used to discriminate against people. So therefore, we're okay. This is exactly the same thing that the ATF did when they were talking about the tactical machining case. You remember that? When they referenced, I think it was Protestants and Native Americans couldn't have guns because, see, we had prejudice laws before, so we're fine. We can infringe people's rights. Yeah, actually happened. All right. Let me show you this. As we get into this, make sure I see some planes if I'm landing it. If not, don't land planes. All right, here we go. The order on the plaintiff's motion for preliminary injunctive relief. I mean, you got to stop it. That's what it means. The plaintiffs in this action challenge the constitutionality of the waiting period after the sale of a firearm. The matter is before the court of plaintiff's motions of preliminary injunctive relief, plaintiff's motion for preliminary injunctive relief, which I now grant. Okay, as we go into this, that's a big part of this story, but I want to show you some other things that FPC posted because these guys do not play, all right? I'm going to walk through this, and as you guys get in here, just know that 72-hour waiting periods just got slapped with an injunction, okay? Though Attorney General Frey concedes that the Constitution makes inviolate a right to keep and bear arms, the weird sentence, he asserts that it does not protect the corollary right to acquire arms, which is a curious construction indeed. And as we keep on going on this, listen to this. Acquiring a firearm is a necessary step in the exercise of keeping and bearing a firearm. Any interpretation to the contrary requires the type of interpretation judiciu that would make Kafka blush. Okay, so what he's saying here, and I'll pull it up so you guys can read it while I'm talking about it. If you're going to basically delay a right, yeah, you're infringing on the right. The time doesn't make it okay, right? So if it's a 72-hour waiting period, all of a sudden, magically, does that mean that your rights are not infringed? It's okay because you have a 72-hour period? No, they're infringed. It's quite obvious. Waiting periods are an infringement upon the Second Amendment. It's not hard. But that even the judges are saying it, okay? That's the important piece. And I'll link everything in the description like I always do. But there's some stuff that I really want to get to. Here we go. Attorney General Frey quotes liberally from out-of-circuit opinions and decisions which apparently represent a surprise revival of the textualist judicial tradition from some rather unexpected quarters. Again, they're pulling everything they possibly can. What they're referencing right there is some other decisions that weren't even in the same realm of concern. And then they're also going to go into the prejudice route. Wow, I cannot talk this morning. Good time to go live. There is nothing novel or nefarious about that basic reality that would warrant torturing the concepts of keeping, bearing, or carrying to exclude from their meaning an acquisition or purchase of a firearm. So again, guys, all of these things are building a case against the fact that just because you want someone not to have a gun doesn't mean you're not infringing if you make them wait 72 hours in a blanket cover. Okay? Here we go. Here's the prejudice part. This is so awesome. This is why it all matters, because they actually went down the Fifth Circuit Court of Opinion that we just had. Amazing. They're all building on each other. Again, same kind of thing. Let's pop this right here. Attorney General Frey also references abjectly prejudicial laws that once banned certain minorities from owning firearms out of a fear of what they might do. Let me actually click on this, okay? This is the left who is arguing against gun rights, okay? This is what they're offering when they're trying to satisfy the Bruen decision. They've done it before in the tactical machining case in Texas. They're doing it now in Maine. Watch this. Okay, I gotta mute this. Sorry, my computer's blowing up. All right, there we go. Assuming that laws offensive to the Equal Protection Clause are appropriate analogs to consider, they are still distinct from a waiting period because a waiting period applies to most everyone without exception, whereas prejudicial carry laws prohibit keeping and bearing arms based on an individual membership in a disfavored group that lawmakers presumed had a predilection or interest in armed insurrection. There was, once again, a standard of work, albeit a bigoted one. Today in Maine, there is no viable presumption that everyone in the body politic, or even the average person who seeks to purchase a firearm, is inclined towards self-harm or other mayhem. Do you understand what this is saying? This is literally saying that you cannot reference prejudicial laws from the past which discriminated against individuals as a reason for your history, text, and tradition. That is literally what they are saying, and they've done it in multiple cases. Guys, you got to spread this stuff out. These people are crazy. All right, let's keep going, though. Here we go. Undoubtedly, deprivation of the right to keep and bear arms, particularly for purposes of self-defense, is of such qualitative importance to be considered irremediable through subsequent relief. Meaning, you got to fix it. You can't do this. Okay? Let's keep going. Although members of the public undoubtedly feel that they have a genuine interest in laws curtailing the right to keep and bear arms, their interest is not exclusive and not one that can win out in terms of an interest-balancing exercise by a court that is sworn to uphold the law. Interest balancing is a thing of the past. Here, look at the conclusion. The remaining elements of the preliminary injunction standard concern the balance of equities in the public interest. Given that plaintiffs have established a likelihood of success and the existence of irreparable injury, I find that the balance of equities favors them as well. Again, this is the plaintiffs, the people suing the 72-hour waiting period. Similarly, although members of the public undoubtedly feel that they have a genuine interest in laws curtailing the right to keep and bear arms, their interest is not exclusive and not one that can win out in terms of an interest-balancing exercise by a court that is sworn to uphold the Constitution. Plaintiff's motion for preliminary injunctive relief is granted. So ordered the 13th day of February. So, guys, and by the way, if you want to follow all this cutting as it's happening, at Braden LOA on X. What we're watching right now is the dismantling of the gun control arguments and the gun control laws downstream of the Bruen decision. They are literally going back and they are having to leverage prejudicial laws against minorities. They've done it multiple times. Like I've said several times in this live. They've done it in the tactical machining case in Texas where they said that Native Americans and Protestants or Catholics, I can't remember which way, couldn't have guns because we made it illegal back then in the 1600s. So it's okay. So we can discriminate now. And now they're going down the same road in Maine. Guys, they got nothing. The only thing that they can reach back in past in history to satisfy the Bruen decision, which requires history, text, and tradition, is literally discrimination. And they're doing it. They want that gun control, and they want that gun control bad. So guys, as we're walking through this, make sure you are sending this stuff out because this is how we win. We just stack and we stack and we stack. And before you know it, there's so much weighing on our side of the scale that it just blows away everything else. This is an amazing win. 72-hour waiting periods just got dealt a preliminary injunction in Maine. More of this, more to come. I can't wait to see you on the next one, and I will see you at that point.